before I move on, I want to bring up California recording laws. Okay, and you have to understand when you can record people when it's deemed private or in a public area, or where a place that two people expect a reasonable amount of privacy. California pretty much was a two-party consent state, but the laws have changed, and so it's actually a one-party consent depending on the circumstances. If you don't know the law, then you'll wind up getting yourself in trouble. Me, I know the law. So real quick, I'm gonna go through this recording law just so that things are understood.
California Recording Law Summary. California's principal recording law, Cal. Penal Code 632, stipulates that it is a two-party consent state. In California, it is a criminal offense to use any device to record communications, whether they are wire, oral, or electronic, without the consent of everyone taking part in the communication. This means that in California you are not legally allowed to record a conversation you are taking part in unless all parties are in agreement. However, there are a few exceptions, such as public conversations with no expectation of privacy, within government proceedings that are open to the public, recording certain crimes. California also has a wiretapping law, Cal. Penal Code 632, which can result in criminal prosecution for the unauthorized recording of a phone line or other media. Unique components. Due to California's heavy involvement with the entertainment industry, the state also has some unique laws pertaining to celebrities and paparazzi. These laws forbid trespassing for the purpose of taking photos or making audio recordings of people participating in personal or familial activity. Cal. Civil Code 1708.8. California has some laws specifically related to paparazzi. The state's vehicle code prohibits anyone from following other drivers at close distances or behaving recklessly while driving with the intent to take photos, video, or record audio of another person for profit. Cal. Ver. Code 40008. Our recommended digital voice recorder. Examples of illegal recording of confidential communication in California. Some common situations where it would be considered eavesdropping to use a recording device. Recording your boss in a meeting without their consent. Intentionally recording your neighbor's private conversations while in an apartment building. Using a recording device to intentionally eavesdrop on a private conversation in an intimate restaurant. Recording public officials at an administrative proceeding open to the public or a public gathering while on official duties. Recording telephone conversations without informing the other party unless you are recording being harassed. When is recording a conversation a crime in California? California Penal Code 632 dictates that all four of these circumstances must be met in order to charge someone under California law. Intent. California law aims to prevent private conversations from being secretly recorded. It is not illegal to record something in a public space and accidentally record a private conversation. Electronic device. An electronic recording device must be used in order to be charged under Penal Code 632. These include microphones, telephones, laptops, and personal computers. Privacy. It must be a confidential conversation where there is a reasonable expectation of privacy. This allows for some wiggle room in the law, as there is a large difference between an intimate restaurant and a public bench in terms of illegal recordings. Consent. On private property or in private settings you may legally record if you gain the prior consent of all parties. California Penal Code 631 relates to wiretapping and makes it illegal to use any method, physical or digital, to make unauthorized access to someone's conversation. This most often relates to phone lines and telephone calls, but can also relate to any other digital method of communication such as VoIP. Recording personal conversations in California. California state law is intended to punish the recording of conversations where all contributing parties have not given consent, but does not forbid such recordings in instances where the communication happened in a public place, during government proceedings, or in a situation where one could be easily overheard by others. You may not record conversations without the consent of everyone taking part. California recording law exceptions. California Penal Code 632 does not apply in a few specific areas. Law enforcement personnel are allowed to legally record conversations that they are not a party to. Police officers may then legally use this evidence for criminal prosecutions. Private citizens are also allowed to utilize these exceptions in a much more limited capacity. In order to use this exception, two circumstances must be met. The person recording must be a part of the conversation. This essentially changes California law from an all-party consent state into a single-party consent state. They must be recording conversations in order to gather evidence that the other party committed one of the following crime: extortion, kidnapping, bribery, harassing phone calls, or any felony involving violence against another person.
Let them know that I know what I am doing.